Do you have a will or trust in place to protect your family and everything you've worked hard for? Join us for a free seminar called What You Need to Know About Wills and Trusts on Saturday, June 6, 2026, from 12 p.m. to 2 p.m. at Temple Church of God in Christ, located at 672 South Lauderdale Street in Memphis, Tennessee. This powerful seminar features a state-licensed attorney ready to answer your questions and help you understand how to protect your loved ones, your property, and your future. Topics include living wills, power of attorney, estate planning, protecting your property, protection from financial abuse, and much more. Don't leave your family guessing. Plan today for peace of mind tomorrow. RSVP by June 1st, 2026. Sponsored by Good Shepherd's Realty and Investment Incorporated. Call the office at 901-767-9102. Text 901-503-3000 or 901-690-3559.
For coming out today to get this valuable information. Also, I want to recognize Bishop Hall and First Lady Hall for giving us the opportunity to use this facility to give out this information. Thank you. Thank you, Bishop. My name is Douglas Bentley. I'm a broker at Good Shepherd's Realty and Investments. And as a company, our goal is to provide valuable information to help individuals prepare for important financial and estate planning decisions. By planning, clients can make informed choices about management and distribution of assets, reducing the likelihood that decision will be made by a judge or a court official. So we wanted today to bring out a probate attorney, two probate attorneys that's been in this business for a long time. So you can get the information that you need to get your plan together for your future and your family. Our first guest will be attorney Matthew Thornton with Evans and Peachtree attorney at law firm. So today I'm gonna bring him on up. So we're gonna get started. And if you have any questions, we'll have questions and answers at the end. But we're gonna go on and get everything started, and so you have your chance to ask your questions.
Good afternoon. I'm going to use this mic stand just in case. Sometimes I like to use my hands when I talk, and so I like having a mic stand as a way of. All right. So I know that you guys are here today to learn about probate and estate and powers of attorney, and we're excited. Mr. Bradley and I have known each other 20-something years. We've been in the business probably close to 30 years each. So we bring some probate experience to this, and I'm personally not upset if you have questions while I'm talking. Raise your hand and I'll call on you, and I may answer. I may say I'm going to answer that here in a minute, but feel free to ask questions. There are no foolish questions. There's only the foolish who don't ask questions. We are preparing for a funeral here at the services today, so we've got to be prepared to vacate the building as early as possible. We're going to go till 2 o'clock at least. There'll be an opportunity for snacks. Before we get focused on the law, I asked Doug's permissions to give a shout out to the Lord Jesus. We're here today, to learn about the law, but He is the great lawgiver. And so I'll preach a little bit. I'm an elder in my church, and I preach on occasion. I'm not the regular elder, but anyway, I'm delighted to be with you today. And I think it's a good reminder that we've all got a funeral coming. So we got to make sure we're right with the Lord. So anyway, all that said, now we're going to talk about probate. Before we delve into the handout, I did want to talk about, anybody who didn't get a handout, there's more available. What is probate? When you hear probate, what does that mean? And all that simply means is going through the legal process of transferring property from a person who has died to a person who is living, their heirs or their beneficiaries, or their charities. You can also name charities in your estate planning documents. So probate is what we do after somebody has passed away to varying degrees. Sometimes it requires court. Sometimes it does not require court, but the process of resolving your estate, using a very general term, your estate, is called probate. And what you do on this side of death is called estate planning, doing wills, doing powers of attorney. So you can prepare for your ultimate death by leaving the people you want to receive your funds, and the charities and the church and whoever else you want to receive your funds. If you want to do that, if you want to be intentional about how you do that now. You do that before you pass away, because once you pass away, if you die with no will, I don't care what you told your brother 3 years ago. I don't care what you promised your child. If it's not in writing and not probate worthy, then we're not going to be able to carry out those wishes unless some super circumstances occur. All that to say that if you don't have a will, the state of Tennessee has a will for you. I feel like my microphone went off there for a second. Okay, yeah, we're back. In other words, the state of Tennessee says, if you don't have a will, here's what happens, and that's part of what my handout will go through with you. Any questions about that? Okay, let's look at this chart. This kind of orients us to the probate process, okay? Everything that you see in the light pink does not require court involvement, normally, okay? And there's a disclaimer, the very first paragraph there beneath the graph says, this chart is for general illustration purposes only, and there are exceptions and special circumstances that may apply. So all that to say is, like any good lawyer, I can't guarantee you, but this is generally true about estates, okay? So you may come to me with a unique situation, and I may say, well, I know what I said here, but it's different in this case. Estate planning and estate law is very complicated at times depending on the circumstances, but we're here today to try to help you understand at least the basics of it and prepare for it. Okay, so to be clear, everything in the pink does not require court involvement. What does that mean? Let's look at the first one in the upper left. If you have a bank account and you own it jointly with another owner, 99 times out of 100, that's going to be, the bank's going to consider that joint account with right of survivorship. What that means is that whoever survives is entitled to that entire account. I've seen parents who have 3 children. They put one child on the account. Well, if the parent passes away, that one child becomes the owner and has no legal obligation to share that account with the other 2 siblings. Now, that may be your intent. But if you set a child up as a joint owner, that child becomes the owner at your passing, if you pass first. All that to say is you want to just, if that's your intent, great. But if it's not your intent, you might want to consider doing a different arrangement, which we can talk more about. A burial policy. A lot of people have burial policies for purposes of making sure that they get buried. If you name Jimmy Joe under a burial policy, Jimmy Joe's entitled to that burial policy. He'll make sure you get buried. Now, he may skimp on the details unless you've directed what those are. But he can keep the balance of those proceeds of a burial policy if there are any balance. Same thing with life estate. If you say, I'm giving him $10,000 to cover my funeral, then it has to be clear that he's obligated to cover your funeral with that. There may be some wiggle room there. Jointly owned, going down the list on the left, jointly owned house or real estate with right of survivorship. That is a very specific creation under the law. Married couples who acquire real estate while married automatically have, for lack of a better way of expressing it, joint ownership. Husband dies, wife gets it. Wife dies, husband gets it. But also other people, siblings can own the property jointly, but that's not the way you inherit property. You inherit property is what's called tenants in common, which means you own your individual 1/3 interest and your 2 siblings own an individual 1/3 interest, and your sibling can give it to whoever they want to, and you can give it to whoever you want to, and you can leave it in your will to whoever you want to. So that gets into heir property, which we'll talk about in the probate estate box, the smaller box. 401ks and IRAs, normally they almost always insist that you have a beneficiary on those. So your company that you have your 401k with, or your IRA broker, whoever it is, normally updates those beneficiaries very frequently. Make sure you have a beneficiary on file, but not always. POD and TOD in the upper right-hand corner. POD is short for payable on death. TOD is short for transfer on death. And those are arrangements that you can make with your bank so that you're not adding someone to your account, but at your death, they get your account. But they don't have any control during your lifetime of the account. They can't access your account. They can't write checks on your account. They just get whatever's in that checkbook or that checking account after you pass away. This is a useful tool to leave property to your children equally. You name all 3 of them, all 4 of them, all 2 of them, whatever. You name them as the POD beneficiary, and your banks can do that. One of the disadvantages going back to the joint bank account is if you name your son as a co-owner on your bank account, and then your son goes through a divorce or a bankruptcy, your account can be sucked into that whole mess. Now, you have rights because it's your account, but at the same time, it's not an automatic thing, and you might have to hire a lawyer to protect your own bank account, which we usually try to tell people to avoid that. When we get into powers of attorney, you'll see that a power of attorney is a much more effective way of allowing someone you trust to get access to your bank account, to be able to write checks, to be able to access, make withdrawals, pay bills, whatever they need to do. And remind me, we'll make sure we talk about that. Next one down on the right column is the revocable trust, often called a living trust. That's a trust you create during your lifetime. And those are very effective tools to transfer your assets from your ownership to whoever you want to benefit. And it avoids probate. It doesn't mean it avoids taxes. And Tennessee is a great state for taxes. It's done away with all death taxes associated with dying, inheritance or estate tax. So a trust is a great way, and it's a smooth transition because after you usually name yourself as the trustee, and then as you begin to feel like, okay, I probably don't need to be managing this anymore. Maybe you're double writing checks and you forgot that you'd paid that creditor, or you forgot to pay a creditor, you're starting to slip a little bit. You can resign as trustee, and then your next named trustee takes over, and it's just smooth sailing from there. Annuities. Some people like to invest in annuities. Those usually have a beneficiary named, and again, that passes without a court involvement at all. It's a contract you have with the annuity company, and they will provide the benefit that you've contracted with them for. And then life insurance in the lower right corner. Again, life insurance, you name a beneficiary. If you have a purpose for why you're giving them that life insurance, meaning I want you to pay for my burial or whatever, that needs to be clear. That needs to be made somehow explicit in the circumstances. Any questions about anything in the pink, not in the white box, we haven't talked about that yet, but in the pink box, any questions about any of those? Okay. Oh yeah, go ahead. You were first. Right. Right. All right, so let me summarize for those who might not have heard what she said. Did your father have a will, by the way? Okay. So her father had a will that designated what he wanted done with his property, his real property, at his death. And this lady was kind of his executor, the person that was managing his affairs, and her siblings were encouraging her prior to her father's death, to go ahead and put that into effect with quitclaim deed. You probably have heard of a quitclaim deed. There are reasons why you would want to do that, but there are also reasons why you would not want to do that. Let me delve, and Anthony's a better person on this topic than I am. He knows taxes much better than I do. But there's a thing called cost basis. If you buy a house in 1980 and the house cost you $60,000, but then it appreciates to $160,000 and you sell it, then you have $100,000 of gain that you have to answer to the IRS for. Now, it could be that it's exempt and you're not taxed on that. But when you quitclaim property, you're conveying it at your basis. Whereas if a person dies owning property, whatever the value is at the date they die, it jumps to that basis. So that if you sell it the next day, there is no gain, because at your father's death, it was worth $160, to use my example. So there's no tax consequence. Whereas if he had conveyed it via quitclaim deed to your siblings, and then you'd agreed to sell the house, you each would have faced potential capital gain tax from having his basis. If he bought the house in the 70s for $30,000, and then now you're selling it for $130, you and your siblings would be taxed on that gain. So there might have been an advantage in not doing that. Now, there are reasons, and again, Anthony's going to be a better topic teller on that one, but there are reasons why you might want to do it anyway, even under those circumstances. And then there are hybrid ways of conveying real property that you can also take advantage of. Conveying a life estate, keeping a life estate and conveying the remainder to someone is another way of doing that. And we'll probably touch on that a little bit during today, either Anthony or myself, and certainly open to more questions about that, okay?
Let me.
Yes, sir.
If you have any questions, you can step up. I'll guide you up to come to the mic so that everybody can hear the question they have as well, okay? All right, thank you.
Had a question?
Okay, come on in. And normally what we would do is have you come up to this mic here. Okay, that's fine.
For years, I've been curious about annuities.
Yes, sir.
I want to know how much it is to start an annuity and when does it mature?
All right. Y'all all heard his question regarding annuities. I'll tell you on the front end, I'm not qualified to answer that. I'm not qualified to answer your question because I don't deal in annuities. And I think there's a lot of different variations, like you can buy annuities that pay you at a certain age, a certain amount. So I would suggest that you consult with someone who sells annuities and get all the details about that. Some people find that an effective investment strategy, but I'm not qualified to answer that. Yes, sir.
On capital gains,
Yes, sir.
could you avoid capital gains if you take the money that was... Could you avoid capital gains if you spend the money before a time limit so that you put the money to work elsewhere? If you make a sale to put money someplace else, could you avoid capital gains?
So if I understand his question in the context that we talked about earlier, that you incur the gain by selling a real estate and you incur, let's say you incur $100,000 of gain, can you then put that money to some use that would prevent you from incurring the gain? I think the answer to that is no. The IRS's position is that as soon as you sold that house, you incurred the gain on that. So there are other ways that we can address that issue ahead of time. In other words, before you sell the house and incur the gain, we can talk about that
Very
type
good,
of thing.
thank you. Didn't know that.
Any other questions on that?
Raise your hand.
Anybody? Good questions. All right, go ahead. Yes, sir. You can do it right there if you got the mic.
Yeah. I had an elderly couple I used to see to,
Yes, sir.
and they did a reverse mortgage.
Yes, sir.
Once he passed and once she passed, now the property is just sitting there. What is your suggestion on a reverse mortgage?
So a reverse mortgage, the way that works, and I'm no expert on that. I have a friend who does that nationwide. A reverse mortgage is where you basically get cash out of your house, not full value because they don't know how long you're going to live, and so they don't pay you full value, but they do give you cash, and then it's just like any other mortgage except you don't have to pay it on a monthly basis. It basically just sits there until you pass away. Then what they do is there's a narrow time limit within which for the family or the heirs or the beneficiaries to say, we either want to keep the house or sell the house, or we'll let it go into foreclosure under the reverse mortgage. So it all depends at that point on what the value of the house is and the value of the mortgage. If the value of the house, if there's any equity there at all, more than 10 or 15,000, it's probably worthwhile to try to market and sell the house, because then you can pay off the mortgage and pocket a little bit. And sometimes the houses have appreciated significantly on a reverse mortgage, particularly those done before 2020, which was COVID, and the appreciation of property values. I had one the other day where a lady had borrowed $350,000 on a $500,000 house or $600,000 house, and the $600,000 house had appreciated up to $800,000. And so it was definitely worthwhile for the family to sell the house to pay off the mortgage, and they pocketed the difference. Absolutely. But I'm not a reverse mortgage expert, so don't take everything I say. Well, really take everything I say today with a grain of salt, but you're fine.
else?
All right, let's look at the smaller box. I've, I've called this box the probate estate. And these are assets that generally require going to court and probating your estate. Not always, and there are ways that you can avoid probate if you have the opportunity to do it. So a solely owned vehicle. Think of this box as pretty much things that are in your name only. Like a lady asked me earlier, she said, my house is in my name only. Things that are in your name only require probate, either utilizing your will that you created, or if you don't have a will, the state of Tennessee has a will. And we'll talk about those on the back of this flyer in a minute. So a solely owned vehicle. Now there is a form acceptable by the state called an affidavit of inheritance. If all the heirs agree, all the heirs can sign. They all have to be competent, and they can all sign over ownership to one of the heirs or a third party, but everybody has to sign a notarized statement in an affidavit of heirship, and that's a form that's available online. Solely owned bank account. If the bank account is less than $15,000, there is a statute that allows the bank or credit union to voluntarily give that to the named executor or the next of kin. The bank does not have to comply with that, in which case you would probably have to go to probate under what's called a small estate. Small estate in Tennessee is $50,000 or less value, not including real estate. So, if there's a bank account out there and it's got $25,000 in it, you can go get that using the small estate procedure, which we can talk about if you need to. Solely owned house or land. Remember that even if you have jointly owned house, if mama and daddy own it, as soon as one of them passes away, it becomes solely owned real estate. Meaning even if mom and dad's name is still on that house and dad's been gone 5 years, mom is the sole owner under the law. So sometimes the ownership records in the public record don't always catch up to the reality as quickly. But the reality is the moment the one passed away, the other becomes the sole owner. That's under the law. And even that's subject to qualifications where if the estate's there's not enough in the estate to pay all the creditors, that land can be brought into the estate to pay creditors if necessary. And that brings me to heir property. Heir property is a very common phenomenon, particularly in Memphis. There's people who've had heir property in their family for generations. And the family normally gets along, or at least is accommodating or accepting of the circumstances. Usually, somebody moves a relative in there and a child moves in or whatever, and everybody's okay with it as long as they're maintaining the property and paying the taxes and that sort of thing. But it can be a problem because if you think about it, let's say you start with a typical mother-father who owned the house, and then they both have passed away and they had 2 kids. Well, those 2 kids may have had 3 kids, and then, then that's 15 people, however many people it is. I don't do math. But anyway, next generation, every generation, you're going to start adding more and more people, large number of people, and their ownership interest percentage gets smaller. In that case, you are not required, even if you got 5 siblings, let's say, and all 4 of the others say, we want to keep the house and we want to move Junior in there. If you don't want to move Junior in there, you have the right to be bought out under the law. That's called a partition suit. Partition, partition suit. Any owner of real property can force either you buy me out or the property gets sold and I get bought out. You are not required under the law to own property with another person if you don't want to. Does that make sense? It's probably, I've thrown a lot at you there and I don't mean to. So if you inherit a 1/3 interest in a piece of property and the siblings insist on, moving somebody in there and they're not paying rent and they're a deadbeat and they're not keeping up with the property, you don't have to agree to that. Now, family harmony is a different thing. I'm not talking about family harmony. I'm talking about the law. Under the law, you have the ability to get out. I want my share. Y'all do what you're going to do, but I want out. So that's called a partition suit, and that can be brought in probate court. Yes, sir.
Should grandmother and grandfather have 200 acres and they're deceased, and the children have all left home, and the land is there. And someone says to one of the other children, sell me your share of the heir property. That's not legal. Or if it is legal, how does one stop one member of the family from selling and busting what the family intended?
So there's two ways you can answer that question. One is you can't stop a person who owns an outright interest from selling their interest. And so in one sense, there's no way to stop that. However, it could have been stopped at the mother and daddy level had they created a trust that limits that, puts the property into the trust and then limits who can own the trust down the road so that no person could sell to a third party. That's not permissible under the terms of the trust. So that's one way to avoid it, but it has to be planned. It can't just be made up after the people who own the property have already passed away. So if mom and dad pass away, 5 people now own 200 acres, and one of the 5 wants to sell, they have every right to sell. And I would say under that circumstance, the other owners have every interest in trying to buy out their share for fair value. And hopefully, the families can work out an arrangement on that without getting too conflicted over things. That answer your question? Here, why don't you speak into here?
So many families are broken apart now because Skippy sold his share and he literally gave it away. And the other family members that lived from California to New York to Detroit to whatever said, now how can we keep this guy now from trying to take the rest of the property? And it all winds up in court because nobody has money just to pay a couple hundred acres out like that. Now the guy that bought the share from Skippy may be very well healed to make that payment. And he winds up breaking the family's hold on the land and taking the land through court.
Well, I'll tell you that can happen. So I don't have a way. Anthony may have a better idea than I do. Again, if you've planned it, he can't buy that property, the third party. But if you haven't planned it and you now got multiple owners of real property, there really, to me, is no way to do it. You could seek injunctive relief in the court, but that's expensive. Short of a trust, I don't know, or putting it in a corporation or something, I don't understand. I don't think you could do it. I think it's a way to do it. Yes, sir. Well, mother and father who owned the 200 acres originally would put it into a trust, and then, the trust would remain the owner for the benefit of the people that they want to benefit from. And so that would not, so when you're a beneficiary of a trust, you don't own that trust property. The property is still owned in the trust. You're just a beneficiary of it. So the income that it throws off, you benefit from normally under a trust arrangement. Again, Anthony I'm looking at you may be better able to give them a good answer on that when it's your turn. You can't take my time. I'm not yielding my time. Yes, ma'am.
Okay, so earlier you were speaking about family homes. So if you have siblings and they pass, you might have 2 or 3 left. Do the siblings that pass, do their children have a right to be part of that?
Yes, and on the back of the flyer, there's a highlighted part. And that I'm going to get into that specific topic when we talk about that. Let me look at my time here. Okay. Finishing up just the white probate estate box there in the center. If your life insurance doesn't have a beneficiary, or if the person you named has passed away, you may have to go to probate over that. Now, each life insurance company is different. Some company may say, well, if you've named Julia and Julia predeceased you, died before you did, then we will pay out to Julia's children. Some life insurance companies say, no, if Julia has predeceased you, then we'll pull that back into your estate and pay it to your beneficiary. So it depends on the insurance company as to how that is going to end up. Furniture, jewelry, typically those are handled outside of probate. by family as long as everybody can get along. But nobody has the ability outside of probate to dictate. Like one family member can't say, this is all you're getting. That's not legal. Now, you may tolerate it, and I'm not saying you should fight every little thing, but without being clothed with the authority of the probate court, you really have no authority to distribute personal property, but people do it all the time. It's a practical thing. Unclaimed property, there's a great website. Tennessee maintains a great website. You can search it by last name and city and try to find property there. Sometimes the small little, $20 here, $20 there, but I actually had a bank account once that had $500 in it. And that for whatever reason we had moved and they'd lost contact with me. And so 4 or 5 years later, I was like, hey, look at there, $500. So it's found money, and you can apply for it sometimes without probate. And then personal injury, if you're injured in an accident and you then pass away as a result of something other than the injury of the accident, then those proceeds are subject to probate, subject to your creditors, subject to going to court. But if it's wrongful death, if you die as a result of the injuries, a bad car accident and you're killed instantly or whatever, that passes outside of probate. Any questions about that? Okay. I do want to spend a little time on the back of this page. Let's talk about that. This is current Tennessee law. Law can change, so hold on to this form, but it may not be exactly right 10 years from now. Surviving spouse has the principle is this: you can't cut a spouse out completely of your estate. So y'all are separated and been separated for years. You really need a good planner who can help you do that, and really divorce is the only way to ensure, and I'm not encouraging divorce, but divorce is the only way to ensure that your spouse can't take from your estate. So just because you got an airtight will, gives everything to the kids and bypasses the spouse can come in with these rights that I'm about to interline for you here. So within the first 9 months from date of death, a spouse, male or female, doesn't have to be any particular gender, can receive between 10 and 40% of the net probate estate. Now remember, net probate estate is the small white box. The pink stuff passes outside of probate. Now, a spouse could potentially challenge, if you've transferred all your stuff to pink and designated beneficiaries, etc., for the purposes of cutting out your spouse might still have the ability to challenge that if they get a good lawyer and the lawyer knows what they're doing. But under the probate estate, the spouse can get between 10 and 40% depending on the length of marriage. Anything over 9 years, you're at the 40% rate. Everything else is graduated up to that. Second point is a year's worth of living expenses called year's support. So you and your husband together, you contribute $30,000 to the marriage, he contributes $40,000 to the marriage. If the husband passes away, you could probably get somewhere, it's judge set, the judge decides how much to give you, but somewhere probably between $30,000 and $40,000 for a year to kind of help that loss, if you will, to help you continue for a year in the lifestyle that you've been accustomed to. The spouse can also be awarded personal property, tangible things you can touch, furniture, jewelry, vehicle, etc. Y'all may remember the old Pat Sajak. What was that show? Vanna White. Wheel of Fortune, yeah. So Wheel of Fortune, probably 20 years ago, the curtain used to come up and everything was back there and they all had prices on it, right? So you've got a $50,000 blank check. You could say, okay, I want that, I want that, I want that, adding up to $50,000. Vehicles included. So if you got a really nice car, the car is, the worth of the car goes into that factor. Although, if, let's say you got a $50,000 car, but it's still got $40,000 owed on it, my argument would be that's only a $10,000 election, you see. So anyway, we can talk more about that. And then an interest in residence. So you and your spouse live in a residence together. It has to be your residence where you're living. And it's only in the spouse's name. Within 9 months, the widow or the widower can assert rights to that, certain rights to that property. Whether it works out to be a life estate or $35,000 from the sale proceeds, there's difference of opinion on that. One of our judges thinks it's a life estate, which I don't think I agree with. But the point is that there are rights, and you have 9 months within which to assert them. And if you fail to assert them within those 9 months, you lose them. So be very aware of that. Okay, the next paragraph down. If you have a spouse and no children, the spouse gets everything in your probate estate. Again, small box, not the big box, small box. If you have a spouse and one child, then after the spousal rights are asserted or dealt with, then it's 50-50 distribution. If you have a spouse and 2 or more children, the spouse gets a third after their rights are dealt with, and then the children split the remaining 2/3, no matter how many there are. So if there's 2 or more, they split 2/3 each, 2/3 among them, I'm sorry. Now this graph, the lady asked earlier, what happens? So X is the example of a decedent in the highlighted part there. A decedent dies having a child A, B, and C. However, C predeceased them, meaning died before they did. So C's interest does not lapse. Why? Because C has children, F and G. And so A still gets their third of mama's estate. B still gets their third of mama's estate. C's third gets split among C's kids. And in this case, there's 2 of them, so they would each get 1/6. Does that make sense? If there were 4 kids, now you're going to make me do math here. 1/3 divided by, that's 1/12 each. Okay? So you can see how the fractions get smaller the more kids there are. Okay. Also, that brings up a point that's not in your handout, and that is if you do a will and you use the words per stirpes, it's Latin, P-E-R, and then a second word, stirpes, S-T-I-R-P-E-S. This is the way it would go. If you use per capita, then you count the number of heads and divide by the number of heads. In this case, there's 4, A, B, F, and G. You divide 4 ways. And that may not be a 100% accurate example of the way per capita works, but that's the distinction between per stirpes and per capita. All right. If you have no spouse, the children share equally. That includes, and y'all will see this all the time, the one who spent their last 5 years not working and caring for mom gets the exact same percentage as Mr. Deadbeat who, didn't lift a finger and lived his life and called mom on Mother's Day. People come to me all the time, well, why can't I get more? Because your mama didn't do a will and you don't have any agreement in place that says that you get paid for all that you did. And the law presumes that if you as a child care for your parent in their dying days, you did that out of love and concern and not for financial reasons. It's only if you have something in writing that contradicts that you would probably be successful in saying, I'm owed money for that, mama. Mama signed this agreement that for every hour of her care or by me giving up my career and coming to care for her. So I would encourage you to consult with a lawyer who understands what they're doing. Mr. Bradley's a good one. I don't do those type things, but to get that care agreement in place to make it fair, because otherwise deadbeat brother gets exactly what you get, and all those years you spent caring for mom while you would have done it for free aren't compensated. Okay? All right. If you have any child that has special needs, disability, any type of, they're getting government benefits, you want to be very clear to do a will before you pass away, because otherwise if they inherit, it could disqualify them either temporarily or permanently from receiving benefits because they're receiving assets. And those, Anthony's a good one to talk about this. I'm glad he came today because he's going to be able to really knock it out of the park on that. Okay, here's right here in the middle. Many parents make the mistake of adding one of their children as a joint owner on a bank account. All they really need to do is have the child authorized to sign using a power of attorney. Powers of attorney are ways that you as a competent adult can delegate that authority to someone that you trust. And Anthony probably sees this too, that is being abused so badly today. You pick the child because they're the oldest, or you pick a child because of whatever reason, And that child starts helping themselves to your bank account as you begin to slip and you're not catching on to what's going on. And then you die, and then all of a sudden your other children realize, oh my goodness, where did all the money go? And it's because the person that you trusted has misspent that. So you want to be so careful who you name in your power of attorney documents. And that's financial power of attorney. There's another way to protect yourself, and that is to have what's called a springing power of attorney. It's the exact same authority that you're giving, but it's only triggered when that sibling is able to obtain a statement from one or two physicians that you're no longer competent to manage your own affairs. What that means is they really have no authority until they prove that you no longer have the capacity to care for yourself and manage your own business. Does that make sense? Now, that is cumbersome. Going to getting a doctor's statement is hard to do sometimes, and particularly, in these day and time of HIPAA and protected information, doctors are sometimes real hesitant on helping you with that process. But just be aware there are ways that you can try to insulate yourself. But the first and foremost is be very judicious about who you pick, because it can be abused very badly. But assuming you pick someone good and trustworthy, you don't have to worry about adding anyone to your bank account because they'll have the ability to access your bank account using the power of attorney. So, but that doesn't if they have a bankruptcy, if they have a divorce, it has no impact on your account because they're just signing as your agent. They're not you, they're not a joint owner, they're just signing as your agent. Yes, ma'am. That's correct.
Power of attorney.
Okay, so her question was, she's got a power of attorney. I'm just going to make up a scenario. She's got a power of attorney. She's named her daughter as the person who's her empowered on the power of attorney. She passes away. She's got a bank account that daughter was able to write checks on. The moment you pass away, other than your final disposition, cremation, etc., your power of attorney loses all authority because you're acting for you and you're no longer alive. So the daughter, as soon as you notify the bank, they're going to cut that account off. Their daughter's not going to be able to write any more checks. Now that's where the POD comes in. You could put daughter on there as POD, and that way all she's got to do is wait and get your death certificate, which takes a week or two, depending on the circumstances. But then she presents that to the bank, and then the bank transfers the money to her or to whoever the siblings are that you've named in that document. But what you're doing is you're insulating your account from any craziness of anybody else. You don't want anybody else. You don't want their crazy to infect your account. You work to save this money, and now all of a sudden, just because you got a divorce going on, your crazy wife wants some of my money, So you're insulating yourself by only allowing people who have the power of attorney to act on your account. Okay? All right. This lady right here. Second row.
Okay. If I pass away and I've already appointed someone to be my power of attorney, and I leave my sister's name on there, how much power does the power of attorney have? Can she go in and get the money when she get ready?
No, ma'am, because you've passed away. Now, if the bank doesn't know you've passed away, I'm not saying it's legal, but if let's say she's been going to the bank for you every 2 weeks, and they know her and they know that she's your sister, and you passed away, and then she went into the bank but didn't tell them that you had died, she probably would not be challenged in what she did, although it's not legal for her. Once you pass away, that authority is gone legally. Okay? So I would not recommend that you rely on that, hoping that she can get in there and maneuver things. Put her on there as a POD beneficiary if you want her to have that money.
Okay, what if you get married and the spouse that you are married to is not the father of your children, and you have a will, and he feels that he has the obligation to own everything that you left for your children, because you didn't put it into a trust? Would he have the right for that, to own the property and your account and everything? Because he was once your husband, but he's not the father of your children.
So
And you did not put his name on the will.
yes, ma'am. So let me. You've asked a very complicated question, and it's going to depend on a lot of different circumstances. But let me give you an overview. First of all, as a biblical woman, it's very difficult for you to marry and not completely, subsume yourself in your husband. So I recognize that, particularly with second marriages where there's children from the first marriage, inevitably that can create conflict and should be managed and spoken about openly as a way of trying to avoid that conflict. Before you ever get married, you can enter into what's called a prenuptial agreement. I'm not necessarily suggesting that, because some people think, well, that creates a wedge from the beginning, between what's supposed to be the closest bond that God created. So it's complicated, but as I said earlier, even if your will leaves everything to your children, your husband still has those spousal rights that he can assert in those things. Now, what I'm sensing is that you're saying he's there. Right.
And then
You did your will before.
say you did your will before you married,
Right.
and you did not put his name on anything,
Right.
because everything you put on your will, you wanted to go to your children. And then he wants to fight the will because he was your spouse. Would he have the right to take what you left for your children?
He would only have those rights that I've identified in this document, these 4 spousal rights that are at the top of the back page with the yellow on it. He would have those rights. Now, obviously, he would not be able to challenge the will. Let me make a quick point. We're going to wrap up my part of it, and we're going to go get some snacks, and then we'll come back. And I'm happy to take questions at the end after Anthony's talk as well. To your point, while you're living, you have no obligation to add him to anything like that. Now, I realize spouses can pressure spouses to do that type of thing. I've seen it work both ways. I've seen wives pressure husbands to do that, and I've seen husbands pressure wives to do that. So, you're faced with a real world situation that's hard to deal with. I would certainly, it's a spiritual issue as well as a financial issue, and I would seek your pastor's counsel on that, how much to include. Now, as far as challenging a will, remarriage alone does not invalidate a will that you did before you got married. If you are remarried and have a child as a result of that marriage, then your will is no longer a valid will, and you have to redo your will. So the mere fact that you got married to him does not negate your will, and the only challenge he would be able to likely raise, effective challenge, would be the spousal rights that I mentioned earlier. And if you've only been married 3 years, then that number is 10%. So, or 1 to 3 years is 10%. One more question.
Okay. Yes. Asking for somebody. Do you have to have a lawyer to have a trust?
Legally, no, I would say. You don't have to have a lawyer on a will. I put in here that even a handwritten will is a valid will. But I've litigated a lot of handwritten wills, meaning I've fought in court over handwritten wills, because a layperson using a word, maybe they use the word property, means one thing to them, but it may not mean that legally. And so yes, a handwritten will is a valid will. A trust that's done can be enforced as a valid trust, meaning it doesn't have to have a lawyer on it. The only reason I would be real hesitant about that is to do it right. I would think a lawyer would be better. And let me give you an example. If your estate goes to probate, at a minimum, you're probably looking at $2,500 to pay a lawyer. Well, that's about what a trust would cost you to do at a minimum, meaning trust could be a little more, but it's one of those pay me now, pay me later. It's almost better to pay and get a trust. Now, the problem with that is, Anthony will tell you, we create trusts all the time, but then you as the trustee have to make sure that all your assets stay titled in the trust. Inevitably, what will happen is a year will go by and you'll inherit money from mama, and you'll keep that in your individual name. Well, then now we've still got to go to probate on that individual account because you didn't put it in the trust. And that happens quite a bit. People do a trust, but then they don't keep everything in that trust. And so you have to be really intentional about keeping things in the trust. But all that to say, to answer your question, I think a trust that you hand wrote out could be a valid document. But I would be really hesitant to tell you to do that without getting legal advice. All right, one more. This lady had a question, then we'll go eat.
I wrote my will, and I stated in there, be it my spouse or my child, I acknowledged them by name and left them $1. Can he protest being the spouse?
Spouse can still assert these rights, even if you leave them $0 or $1. Now, sometimes leaving a person in a will with a certain amount of money is an incentive not to challenge the will. And you can say in there, I leave, say $10,000 to Bobby. But if anyone challenges this will, it's treat them as if they died before me and they don't get anything at all. Well, then Bobby's got to look and go, do I want to take the $10,000 or do I want to challenge Mama's will? So there's ways of trying to disincentivize challenges. But for a spouse, they can still get these rights. You can't cut a spouse out under the law. Now, if 9 months goes by and you've left them $1, then that's all they're getting is $1 if they don't assert their right. All right, let's take a break. Keep your questions if you have more questions. And there's snacks. I know I saw some good cookies as I was walking in here, and I'm going to get one of those. And then Mr. Bradley's going to talk and then take questions. And so if there's any lingering questions, I can come back up at the end, or you can find me afterwards. I'll stay around. Okay? All right. Thank y'all.
Hey, Memphis house hunters, tired of scrolling through endless listings? I've got the real estate secret you need to know. Good Shepherd's Realty and Investment is the game changer in the Memphis market. They're not just any realtor, they're BBB accredited with an A+ rating. That's like the Wall Street of real estate trustworthiness. And get this, they've been in the game since 1994. That's longer than some of you have been alive. Led by CEO Helen L. Jackson, this team knows Memphis real estate like the back of their hand. Whether you're buying your dream home or looking to invest, they've got your back. Don't settle for less. Go with the Shepherds, who will guide you to real estate success. Good Shepherds Realty and Investment, where your property dreams become reality.
At 2:30. So you want to come on up, attorney? Okay, no problem. Well, while they dispersing, we're going to draw a name. Okay. Good. Y'all get your tickets out. Oh, we got one more ticket coming. There was a lot of great information that Attorney Thornton gave us. It's all about planning. Okay. Hope everyone is enjoying the seminar so far. Thank you. years now. He did a lot of transactions for my clients, so I know he was the one of the best person to come in and get this information to us today. And we want to appreciate Bishop Hall allowing us to use this facility to disseminate this information. Okay. We have attorney J. Anthony Bradley with Bradley Law Firm. He's going to talk about elderly law and a few other things that he wanted to discuss with us. So we are going to get this information, eat good, and enjoy the rest of our day. Right now, can y'all clap for Mr. Attorney Anthony Bradley?
Good afternoon, everybody. And there are some handouts here. I just want to say a few things on the front end. I am a firm believer that a trust is always better than a will. So just a show of hands, if you own a home or other real property, even if you own it with someone else, raise your hand. All right, keep your hands raised. Do any of you have minors that are an intended beneficiary of yours, whether it's a child, grandchild, someone you love? Keep your hands raised. Do any of you want to leave money to a charity? If you've raised your hands for any of those things, you need a trust and not a will. Now, I'm going to disagree with Matthew on one thing, which was the cost of probate. He did state the minimum cost of probate today of $2,500. That was pretty much on the cheapest end of a probate administration, which to me would mean a small estate affidavit, affidavits of heirship to pass real property, that kind of thing. But that does not take care of some of the lingering issues of dealing with the Bureau of TennCare or of dealing with other heirs that may not agree with you. Typically, what we see the cost of a trust would be $2,500 to $4,000. But you know, the magical thing about a trust is it's harder for people to contest a trust. Whereas a probate administration, we go to court, we ask the judge to admit the will to probate, or if there is no will, to start the probate administration. And that starts a time period for creditors or other family members to come forward and contest what's going on. So it's really just an invitation. Come on down, everybody. You know, if you don't like what you hear, tell us about it. We're going to have court in the future, and you bring it up, and anybody can sign up for the cost of a pleading. Well, for a trust, the entry ticket for someone to contest is they've got to hire their own attorney. No one else is paying for that attorney for them. With a trust, the only people that get notified of what's in the trust are the people that are named as beneficiaries. So if grandparents decide that they want to, and I'm living with an example of this right now, in my practice, I created a trust in 2015 for a married couple. They were older. They had a child they wanted to disinherit, and they did. They had one child that was deceased. They named their grandchildren as the beneficiaries. Now, that one child they disinherited is serving a life sentence in prison in California. Well, his father died. Years later, his mother died. Grandchildren are the beneficiaries. They haven't shared anything with him. They're not legally obligated to share anything with him. Now, they don't even have to talk to him, and they're not. He has contacted my office several times asking for information, but guess what? He's not my client. As an attorney, my duties are to my clients. So I can't send him a copy of that trust. I did notify the grandchildren that were named as the trustees, and they said, no, don't tell him anything. If he wants to contest it, he has to have an attorney to go to court and to start that lawsuit. I imagine the cost of doing that's probably going to be in the neighborhood of $10,000 to start that lawsuit, because an attorney's not going to take that on and volunteer to knowing they're going to have to file a lawsuit and then take interrogatories and prove to a judge that he has the right to discover what was actually in the trust. He would have to do that first before he could ever discover what's inside the trust. So for those reasons, I believe a trust is better. Another reason that a trust is better is it makes it easy. If I have 3 parcels of real property, and let's say these are the deeds to it, I create a trust. After my death, my trustee can distribute those assets. But now let's take another example. I have minor children or minor grandchildren, or maybe I have adult children, and I don't know that I like some of their life choices. Maybe I have a son or a daughter that has been married multiple times, and it looks like they're going to be a serial serial marriages. But what I can do with my property, and I do a lot of this in my practice and advise clients to do this, is to leave property to their children or their beneficiaries inside of what I call a lifetime trust. Now, it might be that my children are in their 40s and 50s and they're making fine financial decisions. And maybe I love their spouses even more than I love my children. But I still have that lingering thought in my mind of these assets are intended for my children and their children. Should they divorce in the future, I don't want it to be lost in divorce. So I'm going to put the restrictions on it, which I'm entitled to do because we're talking about assets that I own today, right? So I can say I don't intend for these assets to go to my daughter-in-law, my son-in-law. Instead, I'm going to, inside my trust, I'm going to say, I'm going to leave these assets, that equal share. Let's say I have 2 kids, a daughter and a son. And I want my son's share to go into a lifetime trust. And let's say he's 40 years old. He can be his own trustee. But those assets are going to be titled in son's inherited trust, something simple like that. As long as he keeps it titled that way, and it doesn't matter where he moves the money to. It could start out at Schwab, he can move it to Regions, he can move it to Fidelity, he can move it to Mellon. It doesn't matter where those assets are held. The important part is he keeps the name the same. So what we're doing there is we're creating the tools for him to protect himself in the future in case of divorce. So he keeps the name the same. It makes it easy for him in the future, if he is ever divorced, to show, Your Honor, I inherited this from my father, and you can see that from the date of his death forward, it's always been titled as Son's Inherited Trust. We've given him the tools to protect himself. All right, let's say that my daughter is married to a very controlling personality. Maybe she doesn't work. Maybe she stays at home with the children. Her husband works. But I want to protect those assets for my daughter and for my grandchildren. I could do the same thing. You see, now I want to show this. I want to clarify this piece of it. She still has the rights to it. However, I'm dictating on the front end that she's the trustee, not her husband. Now, her husband might say, honey, we really need that money to pay the mortgage on the house. Well, that's really their responsibility to pay for from their assets that they earn. In my opinion, as the father, I want these assets to be held for her retirement, for her contingencies, or to use those monies to help the grandchildren in the future with their education and those things. Those are some things to use. Can you do those things through a will? You can, but you leave it open to being decided by other people in the future. And if my daughter's husband has a more controlling personality, a more dominating personality, and that she will say, all right, well, I'm going to let you make all the decisions with that, then I'm not doing her the justice that I want her to have. So those are tools that you all have. So it's important just to think through what you want, and if you express to your attorney what you want, you can get further. Now, someone asked a question earlier. Can you create your own will? Can you create your own trust? And legally you can. However, if you don't know, and I'm going to say with the age of AI where you can sign on to different software applications and it can draft something, but if you don't know the right questions to put into it, it's not going to give you the right language on the back end of it. All right, part of what we're going to talk about today, and I want to give you this background, is Medicaid. So Medicaid in the state of Tennessee is through an organization called the Bureau of TennCare. Now, in order for anyone to qualify for Medicaid, there are 3 requirements. But first of all, what is Medicaid? Medicaid pays for long-term care housing in case of your disability. It's not medical insurance. Medical insurance is called Medicare. But Medicaid pays for the long-term care housing. Now, all the states across the country over the past 10 to 15 years are really pushing people to stay in their homes, but they're controlling costs that way because there's limits on how much they will pay for someone to stay in their home. And honestly, there are not enough facilities to house people and take care of them medically in nursing homes or skilled nursing facilities. But for Medicaid, for someone to qualify, there are 3 requirements. And this is all background before you get into the papers and the notes there. 3 requirements. First, there is a medical needs assessment. The medical needs assessment for the state of Tennessee says that the patient must have confirmed memory loss and the inability to walk. Now, I've oversimplified that. They've got some more terminology with it. There's 3 pages of questions. But when you look at it, you boil it down, that's what it comes down to. If I ask you the question, raise your hands, who here is looking forward to moving into a nursing home in the future? No one's going to raise their hand, right? Am I wrong about that? I don't believe so. None of us want to. So we all need to prepare, and I'm going to give you a couple of benchmarks to look at and to think about for yourself for what you might need to do to help to protect yourself and to plan. Now, no one wants to live in a nursing home, but if forced to, how do I protect my spouse? How do I protect my family, the legacy that I want to leave to my spouse and my children, my grandchildren? Well, but we have to think ahead. We don't get there by happenstance, right? Now, first of all, do I even need to plan for Medicaid? Well, there's enough, I can build in enough assumptions, they're pretty safe assumptions, that if you don't have $800,000 in investable assets today, you need to plan for Medicaid. The best Medicaid facilities in town or in Shelby County, and I can break it down for you of which ones are better, which ones are mediocre, and which ones are pitiful. Now, the best ones, and I'm going to tell you there are 3. There are exactly 3 that take Medicaid that are good, and you know what they all have in common is that they are all not-for-profits. So they have fundraising arms. So King's Daughters and Sons, Ave Maria, both of those are out in Bartlett, and the Jewish Home. All 3 of those are not-for-profits, and there are groups of people that raise money for those each year. All of the rest of them are privately owned and operated, meaning that people aren't giving excess funds to them and getting tax deductions for charitable contributions. So their funds are raised through what they charge for the patients. Now, I told you the 3 requirements for Medicaid. First, I told you there's a medical needs assessment. The second is a asset test. So for the patient, must be down to their last $2,000 of countable assets. Now we need to come back to countable assets, Matthew. So if you'll remind me to some things don't count, but how do we spend down? But if there is a spouse that's still staying at home, the spouse can have, let me just round to a nice number, $40,000. $40,000 in bank accounts or IRA or other countable assets. Now, some assets don't count. Your home with a value of up to $600,000 roughly does not count. However, Medicaid will put a lien on the house after your death, or after both your death and your spouse's death. Each of the spouses can own one automobile. Now, you may say, big deal, well, if the patient is going into a nursing home and they can't walk and they have bad memory, do they even need a car? Well, maybe not. However, here's the planning opportunity. The planning opportunity is they can own one automobile, even if they don't drive it. It might be that you drive it, because you occasionally take your mother or your father to a doctor. I can't tell you how many times through the years I've worked with families and the family would buy a pickup is the most popular option. But there's no restriction on what that automobile is. It could be a big, high-rise four-wheel drive pickup. It does not have to be a wheelchair accessible van. It can be a sports car. I worked with a family once that spent almost $200,000 on the last year the Porsche 911s, and it stayed there on the showroom floor. They bought it in Florida. One of the grandchildren worked at that dealership in Florida, and the owner had it on display, and it stayed on display. But it was exempt. One automobile is exempt. So that's the opportunity. But now for the spend down items, one automobile, prepaid funerals, because think about it, if your mom needs to go into a nursing home and she's out of money and does not have a prepaid funeral, who's going to pay it after her passing? Now, you're shaking your heads. It's going to be, and I'm going to be more specific. I want to really push you on this. It's going to be, who's going to write that check are going to be the children that are the most responsible and have been looking after mom the most. And I know some of you may feel alone in thinking, I don't get help from my siblings with mom or dad. I don't want you to think you're alone. Now, that's not a good feeling, not getting that assistance, but that's more of the norm these days. That's more of the norm. One of my longtime clients, she fell on bad health. She moved in with one of her daughters. Both of her daughters lived in the same subdivision, about 2 streets apart. And as time went on, mom needed 24/7 care. And when I say 24/7 care, she needed someone sitting with her all the time. And the sister that lived 2 streets away would not come over and stay with mom and let her sister and husband go out to see a movie or go grocery shopping together, so they always did things different, separately. Husband might stay with his mother-in-law. Wife would go out to see her doctor, do grocery shopping. They rarely went out to eat together. And I know some of you are probably experiencing that or have. But now going back, what can we spend down assets on? Medicaid is fine with the patient's money being spent on them. What Medicaid really looks for is to make sure that assets are not given away, especially to family members, children or grandchildren, and that there's not a transfer of ownership of the house, for example. Let me take a rabbit trail real quick since we're on this topic. If you are giving 24/7 care to your mother, your father, for example, and that's really the largest asset, how can you preserve that? Because you got to realize there's a 5-year look-back period from the date of application for Medicaid. All transfers or gifts made within that 5 years, within the 5 years leading up to the date of application, will disqualify the patient and their application. So how do we protect that? Well, first of all, some rules. We've been talking about a lot of the rules of the road today. The value of the property is the tax assessed value. We all get that tax notice every year from Shelby County. And whatever's on that sheet of paper is what Medicaid or the state of Tennessee deems as the value of the property. Now, since Medicaid will not put a lien on the property until after the the patient and their spouse both pass away, whatever debt is on the property will be paid first, because the Medicaid debt does not attach to the property until after the death of the surviving spouse. So what is an opportunity and what works? I'm just going to tell you about things that work. There are plenty of theories across the country that work. There are things that may work in California or New York State or in the state of Florida that don't work in Tennessee. So I'm going to keep it to safe things that are between the ditches. It can be that the son, the daughter, the family members that are giving aid to mom while she's still at home, they charge, but if mom doesn't have money to pay them, guess what? We can create you've all heard of it before, a home equity line of credit. Meaning that, cost of care is high now. Here in Shelby County, 24/7 care can easily be $25,000 a month. 24/7 care for $20,000 a month is cheap. $25,000 is certainly reasonable. $30,000 is reasonable as well. So if you do the math and think about it, $25 an hour, 24/7 is $25,000 to $30,000 per month. So let's say that mom's income is only $3,000 per month from Social Security and a pension, then she's running a $22,000 deficit each month paying daughter as a full-time caregiver. So if there's a home equity line of credit, then that balance is building up each month. Over a year, that's $260,000 of debt that's built up. Do you see where I'm going with that? But for that to work, you have to have your paperwork in order. So we've got to plan ahead for these things. Now, another example might be you see that your mother, your father, or your health is declining. You own your home and you have $100,000 between other assets. Money's in bank accounts, an annuity, cash value of life insurance policies, or stocks. You can hire children or other family members to be caregivers. The state of Tennessee and every other state and the federal government all say that services between family members are gratuitous unless there's a contract. And Medicaid has a litany of items that have got to go into a contract. If we include those things and have a written contract, then it will not be challenged in the future. So if we can get out ahead of this, it doesn't even have to be 5 years in advance. But if we're looking at protecting $100,000 if you give me a year, meaning the patient can live at home for a year, we're going to protect every penny. Well, give me two things. You stay in the house for a year and have someone that you can trust. Someone that's not going to abscond with the funds or waste the monies, and we can protect everything. All right. There is a longer handout. I'm not going to go through it slide by slide, but I want to point out some things to you. Everybody in this room, well, any of us, if we're 18 years of age or older, need powers of attorney. We need a healthcare power of attorney, or medical, and we also need a financial or a general durable power of attorney. And you can name different people for each of those. You might have one child that is a nurse or a doctor that you trust with medical decisions, but can't balance their own checkbook, so why would you let that person balance your checkbook, right? Or if they've been in bankruptcy, or if they have lots of debt. Probably doesn't make that much sense. So that's why I like to have two powers of attorney. Matthew talked about some of these things earlier. Let me just touch on. I don't want you to add people to your bank accounts. I'm just going to say don't do it. Just don't do it. Because when you do, and I am going to look, I've listed 4 reasons, the 4 Ds. So it's page number 4, the top left-hand corner. If you add someone as a joint owner on your account, that exposes your assets to that person's debt, their potential divorce, their disability, and also their death. If you have them as a joint owner with you, and they're not your spouse, then they are a co-owner, meaning they own half of your account. And let's say that you have $50,000 in that account. They pass away, they own half of that account. So their family could claim that entire account since they had access to the full thing. Now, what if no one's trying to take the funds from you, but the person you added to the account becomes disabled and they need to qualify for Medicaid? Then that $50,000 in that bank account counts as $50,000 that they own, and it's going to disqualify them from Social Security, disability, supplemental income, or from Medicaid benefits. So if you have the powers of attorney in place, you don't need to add extra people as owners on your bank accounts. Something else that I think we should all have, and I know you have it at your doctor's office. Everybody here has HIPAA release forms through your doctor's office. So that allows your doctor's office to share your medical information with whoever you list with them. During COVID, I saw this play out time after time, that if someone entered the hospital and they were unconscious on arrival, then the only person that really had access to finding out how they were doing was who? Their spouse. It was really just their spouse. So I want you to have a separate HIPAA release form. That's an extra, meaning in addition to what you have at your doctor's office, so that should you enter the hospital and you're unconscious, that the people on that list can still talk to the doctors and nurses at the hospital, find out how you're doing. And, you know, if they're sitting there with you and you're in ICU and you're unconscious, and if friends and family are sitting there with you, pick out the people that are most likely to be with you to be able to have access to talk to doctors and nurses. Now, is anyone here a veteran or a wartime veteran? If you'd raise your hand. Yes, ma'am? Okay, I'll hold up then. Go ahead.
You have a question? Anyone?
Oh, I thought this young lady had a question. I'm sorry. Oh. What, were you in during wartime?
I'm a disabled veteran.
Well, there are lots of veterans benefits that are available for the actual veteran and the surviving spouse. And many times, veterans or their surviving spouses are not aware of it. So a surviving spouse, through the benefit that's called pension, can receive up to $19,000 per year, and it's income tax free. A unmarried veteran could receive between $27,000 and $28,000 per year, and that's over and above your Social Security and other pension income. And then a married veteran can receive almost $3,000 a month. Now, and so these are some of the rules here that you see on the screen, that the veteran had to serve during it must be a qualified wartime veteran, meaning he or she served at least 90 consecutive days on active duty, 1 day during wartime, and received better than a dishonorable discharge. The second requirement is either the veteran or spouse must need assistance with 2 or more activities of daily living. Now, I will tell you that some of you I know have insurance experience. The VA on this point is easier to work with than insurance companies for proving needs for long-term care insurance. But if someone has confirmed memory loss, or they have great difficulty in walking, use a cane or a walker, have very poor eyesight, then they're going to qualify medically. Now, for financially, they can have up to $162,000 of countable assets. And again, the automobile and the house don't count. but then you can have up to $162,000. But for someone that's living at home, they're going to need some in-home assistance. So if you do have a trusted family member, it cannot be a spouse though. Most always it's a son or a daughter. It can be other people, but it needs to be someone that's close to you that you can write a check to. So I could pay my son my monthly income as a caregiver, because I don't, I know all of you think, well, what about fraud? I've never met anybody that came to me and said, because everyone that comes to me, we're desperate, we got a hard time making ends meet. That dad's income is $3,000 a month, for example. And we're trying to keep him at home, but we can't afford to private pay the rest of it to send him to assisted living. And we can't pay for more in-home care expense. Is there money through the VA? The VA's already told us we don't qualify, so can you help us qualify? You remember earlier I told you about a caregiver agreement? It's the same concept. So if my son charges me, and I've got to put this in writing because he's my son, but I agree to pay him more than what my monthly income is, then that's the last of the 4 requirements. And then if I'm unmarried, I can receive right at $28,000 per year income tax free paid out by month. Now, what's my son going to do with the money? Now, if he takes it to Tunic and spends it, then it's not a good deal. But what if I give my monthly income to my son and he pays the taxes and insurance on my house and on the car, MLGW, the phone bill, the food bill, and does all those things, then it's a really good deal. Now, if you're thinking through this of, well, wait a minute, how does that work? How does that work? Is that not fraud? It's not fraud. If you think about it, if somebody goes to assisted living, what are you paying for? You're paying for the building, you're paying for the insurance on it, the maintenance, you're paying for the workers there. They're providing food for you, so it's the food, it's the utilities, cable, all the other things. So there's no fraud in this. What we're doing is aligning everything so that that veteran or the spouse of the veteran can qualify for those benefits. And the sad thing about that is that benefit has been around since 1789. I'm not a veteran. Do you know how I got into this? One of my great uncles was in World War II. I'd been practicing law for a few years, so I've been practicing almost 30 years now. And he asked me to help him find some benefits. And I found this one, and it took me almost a year to find someone that could help me to understand it. I called the VA. I'm still waiting for them to return that phone call. I went to the basement of the VA hospital, and there's some nice people there, volunteers, but they're not really trained on it because the VA out of DC does not train people on this benefit. So nationwide, there's only about 300,000 people that receive this benefit. But if you think about it, there's still about 1.5 million Korean and World War II veterans living, 7 million Vietnam veterans living, veterans from Persian Gulf War and later could qualify. But just those 3 earlier wartime periods is almost 9 million veterans plus their surviving spouses, but yet only 300,000 people nationwide receive it. And look at this, my son's taking off with my money. Now, yes, sir.
Does your son have to pay taxes on the money that he's given?
I wouldn't. I wouldn't. I'm a retired CPA.
Okay, so that's not income to him?
Well, if he wants to report it, but here, think about what drives income. What drives income? It's when someone takes a tax deduction and reports that tax deduction to the IRS. So I would need to give my son a 1099 or a W-2 at the end of the year. Now, most likely I'm not receiving so much in income that I'm paying much in income taxes anyhow. Plus the monies that he's helping me to procure from the VA is going to be income tax free to me as well. So I'm not going to give him a 1099 or W-2.
Anyone else?
Yes, ma'am.
Yes, you said don't put anyone's name on your bank account. Now, if you have money in the bank and you deceased, who will get it? You want your family to get your money, how will they get it?
Name a beneficiary. Name beneficiaries to that account so that immediately after your passing, once they receive the death certificate, they can go to the bank and claim those funds. Who do you want to receive the funds after your passing? Then I would take your brother off, but you trust him to fill in for you if you lose competency during your lifetime. So you should name your brother as your attorney, in fact, under a durable power of attorney, but name your sons as the POD beneficiaries. Now, we're going to need to go to the back in just a minute. I wanted to point out a couple of the handouts. There's a horizontal handout that's a comparison of a last will and testament to a revocable trust to a irrevocable trust. And so a revocable trust, I've already told you, I believe, is far better than a last will and testament. And so I've got some of the language in there on the cost. Now, a pro of the revocable trust is that you retain control over all of the assets. As we age and we retire and we depend more upon our children or a few people, we may think about that irrevocable trust. So where we have, we have unrestricted trust and who we might name as trustee, because for the irrevocable trust to work, you cannot serve as your own trustee. Now, something that does work beautifully with the irrevocable trust, let's say that your primary asset is your home. Let's say it's paid for and you have $100,000 or so, and you want to retain control over the cash, you could name your children as the trustees. You keep a life estate in the house so that even if the trustee gets angry with you, they can't put you out of the house. And it retains what Matthew was talking about earlier, that the beneficiaries receive the step up in basis. Because what if you did buy the house for $10,000 in 1970 and it's now worth $200,000? You don't want them to have to pay capital gains on it. So this prevents them from having to pay those capital gains. There are a couple of other handouts that are some good pointers. And all right. So we're gonna go to the back now.
We'll go to the back and we're gonna finish the questions and answer. We're gonna eat and talk in the back. We got to.
Hey, Memphis house hunters, tired of scrolling through endless listings? I've got the real estate secret you need to know. Good Shepherd's Realty and Investment is the game changer in the Memphis market. They're not just any realtor, they're BBB accredited with an A+ rating. That's like the Wall Street of real estate trustworthiness. And get this, they've been in the game since 1994. That's longer than some of you have been alive. Led by CEO Helen L. Jackson, this team knows Memphis real estate like the back of their hand. Whether you're buying your dream home or looking to invest, they've got your back. Don't settle for less. Go with the Shepherds, who will guide you to real estate success. Good Shepherds Realty and Investment, where your property dreams become reality.